Order. Welcome to this afternoon's session of the Justice Select Committee, in which we have one witness, which is Sir Brian Leveson. We're very pleased to have Sir Brian before us today to talk about part one of his independent review of the criminal courts. And before we begin the questioning, I will just ask members of the committee to do their declarations of interest, starting with Sir Ashley Fox.
Sir Brian, Ashley Fox, member for Bridgewater. My register of interests contains all of my interests.
Good afternoon, Sir Brian. Neil Shastri Hurst, Member of Parliament for Solihull West and Shirley. My interests are as declared on the register, but I am also an associate tenant at number 5 Chambers and still have a practising certificate.
Good afternoon, Sir Brian. I'm the MP for Folkestone and Hythe. I am an associate tenant at Doughty Street Chambers. My other interests are as declared on the register. I also hold a valid practising certificate as a member of the bar.
And as a King's Counsel.
Good afternoon, Sir Brian Leveson. My name is Lindsay Farnsworth. I am the Amber Valley MP. My interests are as per the register, but of note, for today's purposes, I was a Crown Prosecutor for 21 years before entering Parliament.
Andy Slaughter, I'm the Chair of the Committee, MP for Hammersmith and Chiswick. I'm a non-practising barrister. I'm a member of the GMB United Trade Unions and a trustee of two justice-related charities, Hammersmith Full Law Centre and the Upper Room.
Good afternoon, Sir Brian. My name is Tessa Munt. I'm the member for Wells and Mendip Hills. My interests are also on the register, but I will just point out that two things. One is I'm not a lawyer, and the second one is that I am a Vice Chair of Whistleblowers UK, which is a non-profit organisation.
Thank you.
Good afternoon, Pam Cox, member for Colchester. Interest is declared on the register. In addition, I'm the Chair of the APPG Penal Affairs.
Afternoon, Sir Brian, member for the Forest of Dean. Interest as the register. In addition, I'm a former serving police officer.
Good afternoon, Sir Brian. I'm Warren Just, MP for Wolverhampton West. I'm a solicitor but not practising, and I'm also a member of the GMB Executive Council and member of various APPGs.
Good afternoon, Sir Brian. My name's Sarah Russell. I'm the MP for Congleton. I am a solicitor and I'm a member of various APPGs and a member of community and Asdor trade unions.
I'm delighted that there's a police officer, there are solicitors, and there are barristers, and there are non-lawyers. I think that's a wonderful selection.
We do our best. Thank you very much. So, Brian, if I ask a general question in opening, if there's anything you wanted to say at the beginning, then please do. But essentially, we know why you're here. We know that yours is one of two major reports, along with David Gawke's, which the current government commissioned to deal with crises in the courts and in the prison service. I don't know if I could ask you a general question first of all. When are you expecting to get a response to part one of your part one report? When are you expecting to complete your part two report? And have you looked at consequences between your own work and that of David Gawke as to whether either affects the other in terms of pressure on the courts or pressure on prisons?
Three questions, so let me see if I can answer them. The timing of a response is not in my hands. I do know that the Ministry are actively considering and preparing an appropriate response, which I have no doubt will be announced in the date of which will be announced in due course. I am keen to see the response because it impacts on the second part of this review, which I am presently conducting. I have read David Gawke's report. I've talked to a number of those who were members of his commission, including David Gawke himself. I'm not sure that it really impacts on the work I'm doing because I am not dealing with sentencing as such, but I am conscious of the prison population and particularly the complexities surrounding PECs and escort duties, the only area where there is a potential overlap is in relation to breaches of non-custodial orders and the risk that that will generate more work for the courts. But I don't think that, I think that we fit together rather than oppose.
We may come back to that point later, but you also have said that in relation to your recommendations that they are not a pick and mix series of options. How important is that? I.e., if the government responds saying we like this, we don't like that, how does that impact on your report overall?
So you're absolutely right that I said that this was not a pick and mix, but by that I meant and intended to reflect the need for wholesale systemic reform, rather than a requirement that slavishly the government follow everything I've suggested. So I've set out certain ideas, but I've deliberately provided in some of the recommendations a degree of latitude for the government and ultimately for Parliament to decide what is appropriate and how to approach specific recommendations. But should the broad thrust of my recommendations not be accepted, which is not to say each and every recommendation, but should the broad thrust of it not be recommended, I truly believe that we risk the collapse of the system as we presently have it. And we would then fail in our duty to victims, to witnesses, to defendants, and we would diminish public confidence in the rule of law.
Yes, just one final question for me for the time being. You didn't publish the individual responses you had to your consultations. Was there any reason for that, and are you intending to do so at any stage?
I did not publish the individual responses. Some of them were. I didn't call for evidence in that sense. What I did rather was ask people for views, and I'm not entirely sure that I had appropriate permission to publish what people were saying. If they want to publish what they said to me, then that's perfectly in order. I have published some detail of what people said, but then I got permission from them to name them. But the people who I spoke to are set out in an appendix to the report, and I've tried to cover every single aspect of criminal justice and all aspects of parliamentary input.
Thank you. Let me pass over to Pam Cox.
Thank you very much, Sir Brian. I'd like to talk about the removal of the right to elect, if we may. That your recommendations of the removal of the right to elect to a Crown Court trial and the reclassification of certain offences as summary only would substantially increase the volume of cases going through the Magistrates Court. Do you think the Magistrates Courts are currently able to accept that additional workload?
That's also a good question. I do recognise that more work will go through the magistrates who are themselves under pressure. One of the recommendations I make in relation to the present appointment of Deputy District Judge Magistrates Courts is that all those who satisfy the merit test for appointment should be appointed, and that there shouldn't be a limit on those in order to increase the availability of magistrates' output. But I recognise that, and I've made recommendations, I believe, as to the need to increase the number of magistrates from all sectors of the community. Magistrates perform an absolutely invaluable service, representing their communities and giving up their time for little public reward, and that's a very important part, in my view, of community engagement in justice. I know that creates a different question, which I'm sure I'm going to be asked.
Yes, indeed. Can I move on to a question around data for committals for trial in the Crown Court, which show that for 2024-25, around 6% of those cases resulted from defendants electing trial, whereas 57% were directed by magistrates. So are magistrates currently allocating either way offences to the Crown Court that should be retained in the Magistrates Court? And if so, why and what can be done with that?
Well, so there are a number of reasons why this happens. The first may be that the police and the CPS are being risk averse about whether magistrates should be able to retain jurisdiction in a particular case. I'm not sure why that should be, because on conviction, if the sentence would exceed the powers of the magistrate, they can commit for sentence. But also, it may be that a number of defendants who would otherwise elect trial then get their legal team to say, well, actually, isn't this suitable for the Crown Court? And let's be a little bit fair to magistrates here. They only have the submissions made by the CPS and the defence. They have no external knowledge of the case, and it's quite difficult for them to decide, actually, we can retain jurisdiction in this case if the parties are saying, no, it ought to go to the Crown Court. Depending on what is decided about the Crown Court and the way in which cases are tried there, I anticipate that there will be a greater willingness to leave cases in the Magistrates Court rather than send for trial. But I have no doubt that far too many cases get sent for trial which should be retained in the summary court.
My colleague Lindsay was going to come in with a supplementary then.
Thank you. Just on the point of case allocation, obviously in the Magistrates Court, as you said, the prosecutor will make representations, and the defence will make their representations as well. But the magistrates are the ones that make the assessment as to whether it's suitable for summary trial or not, based on their sentencing powers, and it's taken on the prosecution's case at its highest. I'm just wondering whether, in cases where the magistrates are saying that they feel it is suitable for summary trial because their sentencing powers are sufficient, whether there's an argument to stop Crown Court election altogether for defendants, given that the magistrates have said our powers are suitable. And I know in your 2015 review that was a view that you took.
It's not just me. Go back to Sir Robin Ould in 2001, and I debated long and hard about whether to pursue what I'd said in 2015. You're quite right, that actually courts should decide where defendants are tried, not defendants. It happens in family law. You don't get to decide whether you're a magistrate, district judge, circuit judge or high court judge. It's the court that decides. The reason that I didn't go with that suggestion here goes back to the question about community engagement. But if the government chose to decide to remove the right to elect entirely, that's entirely consistent with what has been said over more than just Sir Robin Ould, but I think Neri and others before them. It's a matter for government and ultimately for Parliament.
In your review, you said that you've changed your view on that. Have you, or?
No, I changed my view because of the balance between community engagement and no community engagement. So also talking to a number of people, including those who serve in your house and the other place, I was encouraged to take a slower line on the basis that it would be easier as a mechanism for Parliament to adopt. And I need this to work. I really do need it to work, because when I talked earlier about the risk to criminal justice, I wasn't, this isn't hyperbole. You might think, making a slightly different point, you might think that since the end of last year when I was set up, everybody, police, CPS, defence lawyers, courts, would be doing everything they could to try and speed up the rate at which cases are being resolved, to demonstrate that you don't need a systemic reform. Yet the backlog has increased and continues to increase. So that might be for a number of reasons, but it is the case. Now, some Crown Courts are doing very well, but in at least one Crown Court in London, they're listing cases at the end of 2029. That is a complete denial of justice. So I've tempered my view rather than changed it.
Because of the constraints that has been put to you?
Yes.
From government?
Well, not just government. It's not. I've seen and met politicians of every single political no, that's not true. Of the main political persuasions, and seen the Bar and the Law Society and Silex, every single body that is involved with criminal justice, and I've tried to find something that is not only workable but doable. Now, removing the right to elect entirely, which is the question you asked me, does away with the need to reclassify, does away with the need to remove the right to elect in certain cases, and in some senses is a cleaner solution. That, with great respect, is a matter for you, not for me.
I think in 24-25 there was 4,283 defendants elect Crown Court trial, so that would be 4,283 last year that would have stayed out of the Crown Court in an instant.
Yes, because in each case the magistrates had accepted summary jurisdiction. I also suggested that should be, if they want to keep the right to elect, you should reverse it and let the defendant elect first, so we know who is not prepared to be tried in the Magistrates Court, rather than only allowing that card to be played after summary jurisdiction has been accepted.
Can I just ask you about that? What's the thinking of that? Because it would save a little tiny bit of time on each of those allocation hearings, wouldn't it? But it doesn't change the result.
No, it doesn't change it at all, except for this. You then know how many cases truly defendants are electing trial, rather than, I mentioned before, the possibility that a defence lawyer might say, well, actually, you know, this really should be tried in an indictment for reasons whatever, and so the prosecution agree with that, and therefore the submission is made to the magistrates, who of course have their own decision, but it's quite difficult for them to second guess both prosecution and defence. So by reversing the decision, you find out immediately who is prepared to be tried in the magistrates and who wants to go to the Crown Court. I think that's not unimportant, that we have a true number of people who, whatever happens, are going to go to the Crown Court. That's why I suggested it. It does save some time, because once somebody's elected, you don't need to decide whether you would accept summary jurisdiction. But it wasn't a time thing. It was a trying to get the system right and proportionate. I have not just been driven here by money. I've not been driven by money, particularly. The principles I've set out in the review, which I'm sure you've been able to see.
Well, let's go on to some of those principles for the the right, staying on the right to elect. So you recommend removing the right to elect trial for offences with a maximum sentence of 2 years, and describing them as the least serious of the either way cases. But you also have identified a pool of offences, additional offences, that could also be removed from the right to elect. And you've based that on the average sentence length, such as, you've based that on the average sentence length, but in that list there are some offences which I think some people would class as not being in the least serious category of offences, such as possession of prohibited images of children. So how would you respond to concerns that some may have raised about taking the right to elect away from people in those sorts of cases? There's been some suggestion from some quarters that that's disproportionate.
Well,
so this is the opposite of what I was saying a moment ago.
Yeah,
I understand that. But
yes, it is. So I've taken average custodial sentence lengths and even allowing for outliers, the number of people sentenced outside that range is really very, very small indeed. And the point to be made is that if you take images of children, depending upon the number and type of images, all sorts of other offences may be being committed as well. I don't think that I'm depriving the criminal justice system of the mechanism appropriately to deal with that sort of offence. It's not my intention to deprive the system of an appropriate sentence in those cases.
And of course the magistrates will have looked at the facts of those cases as outlined and decided that they were suitable for their sentencing power, that their sentencing powers were sufficient. But if it turned out that it was more serious when the evidence was heard, presumably they would still have the option of committing for sentence to the Crown Court if they felt they needed to. Is that my understanding?
In relation to certain offences, certainly. A lot depends upon what decision is made about the overall right to elect, because all this only works if you are restricting but not removing the right to elect, which I've not suggested, as you know.
Yeah, there's no suggestion that we're not going to be, that the magistrate's ability to commit for sentence is going anywhere in the review, is there?
Now I've got to go back to the language.
I don't think there is, but
Thank you.
Thank you.
Thank you. Tony Morgan, do you want to come in?
Lindsay dealt with the point I was going to.
That's fine. Varying the order slightly, Neil, did you want to come with your questions now?
Just keep on the same theme,
sure.
if we may, Chair. So, Brian, just staying on the theme of the right to trial by jury, the Bar Council and the Criminal Bar Association have warned against some of the proposals that you have set out in your report.
I know.
I'd be interested to hear your response to their concerns, and why you perhaps feel their views are not justified, or their warnings are not justified.
Well, first of all, everybody has a right to a fair trial. I think some of our continental partners would be shocked if they believed that their systems of justice, which do not involve jurors, were considered unfair, and 90-something% of cases are tried by magistrates without being considered unfair. My problem with the Bar Council's response and the professional response, which I understand and which I think I might have been able to visualise. I am a barrister by training. I have spent 55 years as a criminal lawyer. I believe in the system, but the system can't survive as it presently is. And what I have said to the Bar and to the Law Society and to others who say, well, a bit more money and more sitting days will solve it, it won't. as I've just tried to illustrate by what's happened over the last year. And if you look at just increasing sitting days, which is what the Bar Council have suggested, there are far too many ineffective cases because there isn't a prosecutor or a defence lawyer in court. So if you increase the number of sitting days, you're going to increase the number of cases where there isn't a barrister or a solicitor in court available to prosecute or defend the case. So just increasing the number of sitting days doesn't get you over the problem. Equally, there is a limit to the number of days we've got for judges. Now, I know that there are complaints that courts aren't sitting, although I believe, certainly the government have said that they've now allocated more sitting days than ever before. The fact is that cases have become more complex, they take longer. I remember when I started the bar, I'm afraid that was in 1970, I could do 2 or 3 days, 2 cases a day. And I vividly remember starting a third with 2 juries out, considering it. Now nothing takes longer, less than a day and a half, 2 days, nothing, because of complexity, for good reason. The second question that I would ask the Bar and the Law Society is, if not this, then what? How are you going to cope? Because the present system, which deprives victims, witnesses and defendants of a trial within years, simply isn't sustainable in my view. So it's no good saying just give us more days and some more money and it'll all work out. I do not believe for one moment that it will. And I've grown up with juries. I'm not in any sense averse to juries. As I say, 55 years as a barrister, as a judge. So, if not this, what? And I haven't got an answer to that question. And nobody really gives me an answer. They just say more money and more days.
Just picking up on a couple of things within your answer. At the beginning, you used a comparative with European systems of how they hear trials. But of course, it's been a cornerstone of the British justice system to have trial by jury for 1,000 years or so. Do you think there is a risk of changing that system undermines public trust and confidence in the criminal justice system in this country?
Well, I'll say 2 answers. First of all, it hasn't been 1,000 years. If you go back 1,000 years, the jury system was very, very different. If trial by your peers from Magna Carta was actually barons trying barons. It wasn't serfs trying serfs, as it were. Secondly, it then developed into a jury system where they specifically wanted jurors who knew defendants because they would know whether the defendant had done it. This is all medieval history, which I've long since forgotten. But I take your point about confidence, and I understand the challenge of persuading the public that they can have confidence in a system which is different. There are a number of arguments I would suggest that really deal with it. First, you will get the defence and the prosecutor and the public will get a reasoned decision. In other words, they will understand why a particular decision has been reached by the fact finder. Secondly, how much confidence truly can there be in a system if a defendant isn't going to be tried for 4 years? How many victims abandon their cases because they need to move on with their lives? How many witnesses lose interest in remaining involved or are even prepared to remember what happened 4 years previously? How much confidence can there be in a system where trials are delayed for that period of time? So I take your point, I understand it. It will be a job for many to try to demonstrate that this does work. interestingly enough, diplock courts in Northern Ireland do not achieve public opprobrium because they're not jurors. There have been a few trials in this country without a jury if there's been impact on jury interference. The judge can discharge the jury and carry on himself. And there have been a number of such cases, not many, but a number of such cases with reasoned decisions, and that hasn't caused public outcry. Of course, you may say, well, there have only been 2 or 3 cases, which is a fair point. But if not this, then what? I repeat for the 3rd time, I'm sorry.
Hopefully you won't repeat it again with my final question, but you raise the complexity of cases. The Institute of Government has set out that they think a number of the growing backlogs in cases are to do with productivity gaps, so transferring prisoners from prison to court, administrative, if I can put it that way, challenges. How do you respond to their suggestion that if you address that, you wouldn't have to reduce the number of jury trials that need to take place?
With great respect, I don't agree with them. I think they're right. I think the efficiency and effectiveness of the court has been diminished for all sorts of reasons. The reduction of resources for the court system, complexity of trials, COVID, all these were important features that have contributed to the backlog. But we're not talking about modest change will move the dial. Modest change, I don't believe, will move the dial. Now, I haven't discussed with the Institute of Government how they reached their conclusion. I'd be very happy to discuss it with them, but my view, which I come to with reluctance, as I've said, my background speaks for itself, is that nothing short of real systemic change will allow us to deal with cases within a reasonable time. There is no doubt that there are problems with the escort system. I don't entirely blame them. The prisons are running, as everybody knows, very hot. There is a real capacity problem. People can't necessarily be accommodated in their local prisons, which means that their travelling time to court dramatically increases. One of the things that I've suggested is, or will suggest in the efficiency review, I give you a forewarning, is more by way of video hearings. Not trials, but all the other ancillary hearings. So I understand what the Institute of Government have said. I just don't think they're right.
Thank you. You clearly struck a chord, as I've now got Sarah, Tessa and Warinder who want to come in on this. So, Sarah.
Thank you, Sir Brian. You referred to the fact that even if we had more sitting days, there are regularly problems with there being no barrister or no CPS representatives in court. Do you think that, A, these suggestions solve those problems because people will still need to be defended? And what do you think needs to be done around that? And what do you think needs to happen to legal aid rates?
Well, I do talk a little bit about legal aid and about the way the legal aid system operates, which I believe needs review, and I've made that clear. I think, of course, the number of barristers won't necessarily increase, although I have made recommendations in this report, for example, in relation to matched fund pupilages, and looking for ways to encourage young lawyers who have a real interest in the criminal law from pursuing that interest, encouraging them to pursue that interest. But the other feature that's important is that if the other recommendations are made, and for example, if there is a bench division, the work will be done much, much more quickly. So you'll get through much more work in time. And I would hope that in that way you'd be able to bring cases forward and thereby in part manage a slightly different problem. At the moment, if somebody knows their trial isn't going to be till 2028, what is the incentive for them to plead guilty? Even though they know and the evidence is there. So I vividly remember advising clients in the 70s, well, if you've done it, you're much better saying you've done it. You can explain it, which always contains some mitigation. You can express remorse, and there is a pragmatic discount for pleading guilty. And more than one client would say to me, you know, Mr. Leveson, I tell you now I will plead guilty, but I want to spend Christmas with my kids. So now they can say, I want to spend Christmas 2028 with my kids. And I just don't think that's acceptable.
Yes, thank you. Can I just check my understanding? I think it's juries are only used in 1% of criminal trials. And I just wondered how much difference it would really make to cut back on those. And my sense was that the problem with the criminal justice system is not necessarily having too many juries. So if replacing jury trials make up only 1% of all of the criminal cases, would that really have a financial impact substantial enough to truly improve the criminal justice system? Am I right?
Well, I'm not sure about the 1% figure. I know it's a small single-digit percentage, yes. But those are, I anticipate you've actually excluded those cases which plead guilty before, just at the day of the trial, which has all been planned and ready to go, and then a defendant pleads guilty, becomes a cracked trial. But you only need to look at the figures, the number of days that Magistrates Court sit and the number of days the Crown Court sits to deal with its work, to realise that however small the percentage, they're taking an unbelievable number of days to try the work that they're doing. Cases have become, as I've said, more complex, they take longer, and they are costly. They're costly for jurors, they're costly for witnesses, they're costly for everybody. So I recognise that it's only a small number of cases, and I'm not suggesting for a moment that all jury trials should be abandoned. Indictable-only offences should always be tried by a jury, except in certain circumstances which I discuss in the report. But that it would make a real difference, I have no doubt. So I recognise the percentage, whatever number it is, but if you consider the number of the comparative costs of magistrates' courts and Crown courts, I think you'll find that they are in substantial imbalance and not in proportion to the figures that you've identified.
Thank you, Sir Brian. My question is actually linked to the question that Sarah asked. You've said that increasing the number of sitting days will not make much of a difference because we don't have enough prosecutors and defence counsel. I assume that we will have a similar problem with not having enough judges as well. I just wanted to know if you have a particular opinion as to why we don't have enough prosecutors and defence counsel and also perhaps judges as well.
Well, you're now foreshadowing something I'm going to spend a chapter discussing in part 2. But I think it's clear from part 1 that the criminal law has become less attractive for legal professionals, although as undergraduates this is the fascinating area, and let me make it abundantly clear from my own experience, having the privilege of being involved in criminal cases as a prosecutor, as a defence lawyer and as a judge, having that window on human experience trying to understand what's happened when your client, if you're defending, barely understands how he or she has come into the position they're in, has been a real privilege and I say honour, and I do mean that, to be allowed to be involved in the system. But we need to encourage youngsters to become barristers and solicitors. If you look at the statistics of the number of criminal legal aid solicitors, there are some who start young and there are some very old. The old are dropping off and the young are moving on and they're doing other work. So they're getting involved in public inquiries. They're getting involved in regulatory work, both of which are rather better paid than crime. So we certainly do need to look at the way in which crime and criminal work is remunerated, because it is a critical part of our system. I said before that one of the challenges has been the way that justice has been the subject of austerity measures, substantially reducing the amount of money that goes into the system. Well, you will have your own understanding of the reasons for that, but the impact is that it's not as attractive a field of work, and it damages our democracy if we don't have a mechanism promptly and fairly to reduce, to ensure that people are tried and that their complaints of criminal misbehaviour are addressed, whether that is a Rasso victim or a victim of fraud or whatever crime you want to identify. So that's the lawyers. That works into judges too, because you need experienced criminal judges, because some of these cases are exceptionally complex and difficult. So we need to look at how we're appointing judges and how we're allocating their work, which has itself its own problems. So we've got to be aware of their mental well-being as well. I vividly remember when I was president of the Queen's Bench Division dealing with a circuit judge who'd tried 14 rape cases on the trot. Well, that's just not terribly helpful or healthy, and causes stress and anxiety and mental ill health. I'm not suggesting that judge was mentally ill, but you understand precisely what I mean. So we need to look at the system holistically, as a whole, which is why I say this isn't a pick and mix. I go back to the very beginning.
Thank you. Have you finished for now? Thank you. And in that case, I'm going to go on to appeals and to Tony Vaughan.
We've not done reclassification.
I was asking, did you want to ask on reclassification or not?
Yes, yeah.
Okay.
Yeah, so if I can ask you a question on reclassification of offences. So your proposal is to reclassify some offences to summary only, and that would include, say, breach of a restraining order or an offence of disclosure of private sexual photographs and films with intent to cause distress. Now, both of those offences can cause a lot of distress to victims. The other point is that breach of restraining order currently has a maximum sentence of 5 years, but the proposal would then be to reduce it to 12 months. So do you think that having this reclassification, number one, diminishes the harm that experienced by victims, and secondly, removes the deterrent effect of having sentences?
So again, you go back, this fits into a question that I was asked earlier. You go back to the average custodial sentence length, and I think you'll find that the average custodial sentence length is well within the sentencing powers of the magistrates. And as regards deterrence, I'm not sure I would like to go to prison even for a day. And those who, well, actually I wouldn't, and those who commit offences, it's not so much that they'll get 9 months as opposed to 18 months. It's that they'll get caught and that they'll get swiftly brought to justice and they will be answerable for what they've done immediately. That's what's critically important about breach of orders and other offences, that you diminish the prospect of avoidance of guilt and you increase the prospect of being brought to account. So I'm conscious of the impact of this, but if nobody is receiving anything like that sort of sentence for this sort of offence, you've got to decide, is that the right sentence? Is the maximum correct? Now, I'm not second-guessing Parliament, far be it from me to do that, but I am concerned that we should try and get cases tried and disposed of at the right level, and we shouldn't push cases into pigeonholes. So Parliament decided that an assault on an emergency worker should have a maximum of 2 years imprisonment. The result is that what was common assault or assault of a police officer, now, which could be dealt with summarily very quickly, now results in many of these elections for trial, going off for years and years. And that means there isn't a robust, critical, immediate accountability. And it's that I'm really aiming at.
So just to clarify that I've understood your answer, what you're saying, Sir Brian, is that for somebody who commits a crime, the danger of being caught and being locked up quicker is more of a deterrent than thinking they'll get 5 years instead of 12 months in prison.
Well, you're right, but they won't get 5 years. Now, I'm not suggesting that they study the sentencing guidelines, although they're online for anybody to read if they want to. But I believe, and this is a more general philosophical jurisprudential point, I believe that deterrence is rather overrated, and being caught and brought to justice is a far more effective deterrent than whether you get 3, 4 or 5 years. The truth is that people who commit crime don't say, well, actually, I won't do this because I'll get 5 years. They'll say, I won't get caught. And the trouble is that at the moment, they might not. Or alternatively, they'll be able to delay it for years and years.
Thank you.
Thank you. Is he got to
Yes, you've obviously talked about deterrence a lot there, but in terms of the sentencing range, you've based this on average sentence lengths, but there are occasions where a much more serious offence within that definition of the offence has been committed. Do you accept that you would be reducing the possibility of somebody who has committed a much more serious version of that offence from getting what the sentencing guidelines would provide a higher sentence than what will be allowed under this?
Well, it may be they will, but if they get caught and sentenced quickly enough, then that's the deterrent.
It's not just about deterrence, is it? It's about appropriate levels of punishment.
Well,
and if the sentencing guidelines at the moment have been drawn up based on consultation with people within the criminal justice system, with the public, with outside agencies and charities, etc. So those guidelines have taken into account a lot of evidence, and we're suddenly saying, actually, for those most serious offences, which the guidelines might say are 4 years, now is only going to be 12 months. Do you accept that there's a big disconnect there?
Of course there is. But the maximum was decided by Parliament, and therefore the sentencing guidelines, speaking as a former chair of the sentencing council, will of course reflect the will of Parliament. I understand that. And it may be that the consequence of this conversation is that members of this committee will say, actually it's better to remove the right of election, and they're not going to be concerned with this at all. I leave it to you.
Thank you.
Thank you, Chair. So, Brian, I just want to talk about appeals from the Magistrates Court. So your recommendation is that we essentially move towards a test as if you were appealing from the Crown Court to the Court of Appeal. But since appeals are only making up about 4% of the open caseload, yet they're succeeding in about 40 to 50% of cases, is it really justified to substantially reduce the right of appeal?
You've got to look at the whole thing. So I am suggesting that magistrates' courts should be recorded and potentially transcripts prepared. I think that is going to alter the way in which magistrates' court proceedings are undertaken. Magistrates at the moment have to give reasons for their decision, and I see no reason why, if there is a transcript, there should be a better system of appeal from the magistrates to the Crown Court than from the Crown Court to the Court of Appeal Criminal Division. On top of that point, I say this. One of the persons to whom I spoke referred to the number of appeals from youth courts in sexual offences to the Crown Court on the basis that the victim, having been through it all once, wouldn't want to go through it again, and many didn't. And I find that a rather disturbing analysis of the position. So, is it a critical part? Could you do it without that? Yes, of course you could. But I've tried to look across the system to be proportionate, balanced and fair to everybody. And I think recording magistrates' court proceedings is a real plus and a significant contributor to improving the quality of justice that we receive.
And what is your analysis about why so many appeals are successful? I mean, you've just referred to one example where the victim doesn't want to go through it all again at a full rehearing. But I mean, are there any other factors here that we want to be aware of, that we need to be aware about, so that we
I think that I haven't done the analysis on this, but judged by my own experience in a fair number of appeals, people weren't prepared to do it a second time, and the engagement and involvement had gone. I think that there are other cases which actually could have gone back to the magistrates. I've not suggested removing the statutory declaration that you weren't served with the papers to go back to the magistrates, and I've not suggested repealing, I can't remember whether it's section 142, I can't remember. You're the King's Counsel. That allows you to apply to the magistrates for a rehearing. I've not suggested amending that, and that might be a better way of seeking to explain why you feel things have gone wrong and why you feel there ought to be another hearing.
So what do you think are the practicalities of recording? Because I mean, there's a lot of audio to store. There are practical factors relating to storage and cost and things like that. Is there a sort of ready-made solution that you have in mind?
Now on your telephone you can record every single conversation you have. Teams will not only record your video but also transcribe it for you. AI has a phenomenally important place. So I'm not suggesting stenographers. I am suggesting using comparatively straightforward recording mechanisms. You wouldn't need 20 recording microphones. you'd need one for the judge, one for the witness, and one for the advocate. And if it needs to be transcribed, it needs to be transcribed. If it doesn't, after a month or so, the time having expired, you can destroy it. It's just gone. So if it's required to be transcribed, that AI will now do that in a very effective way, in the same way that I'm keen to encourage the use of AI for translation purposes. I vividly remember conducting a trial or being involved in a trial in Liverpool in the 70s, where after 4 days we realised the interpreter didn't really understand what the witness was saying. We had to discharge the jury and start again. It's an anecdote, but although people say, well, AI translation is not very effective, how effective is human translation? I'm not suggesting we just march into this area, but I do believe these are very significant and important developments which the court should be using, trying, piloting and developing so that we can make the system as effective as possible.
Okay, just lastly on this point, so just so I'm clear, is the proposal to change the appeal test dependent upon recording? So is it only going to be viable if we have the transcript?
Yes, because otherwise, how would you ever discover whether there was a point of law? I'm not suggesting removing the right to appeal by way of case stated, because I think that's quite valuable as a way of challenging a pure question of law. But you could do it either way.
Thank you, Chair. Sir Brian, my questions relate to your recommendations 27, where you recommend a 40% reduction in sentences for an early guilty plea. Do you think there's a risk that increasing the maximum reduction in sentence length for an early plea may place pressure on defendants to plead guilty inappropriately? And if so, how would risk be mitigated in those circumstances?
Well, I hope not. At the moment, the discount for an early guilty plea is a third, so I'm only suggesting increasing it by 7%. Certain in my practice always to say, under no circumstances do you plead guilty if you didn't do it. But if you did do it, we do need to cut out of the system cases which defendants are gaming, are playing the system. And I need to be an adequate incentive to do so before everybody's done the work and before the case actually has to come to court. A corollary of my 40% is that I've suggested, and of course it would be for the sentencing council to decide, that there should be a wider discretion after the first opportunity. And I'll tell you what I mean by that. If somebody is caught red-handed with his hand on Granny's teapot in somebody else's house, to say that he should have a percentage, 25% after the first stage, when lots of work's had to be done, I think is not necessary. Equally, to say that to somebody who pleads guilty on the day before a 9-month trial, which is going to cost the state an unbelievable amount of money, to say that's restricted to 10%, the judge needs a discretion to be able to reward appropriately, having regard to all the circumstances of the case. And so I would hope that nobody would plead guilty because a discount of 40% was available. I hope that nobody pleads guilty because a discount of a third is available. But I am encouraging the court to be much more prepared to discuss this sort of question, as you know, in the reference to Goodyear. And there's a case called Reading, which adds to Goodyear, to try to ensure that only those cases which require a trial go forward to a trial.
Thank you. Second, the Independent Sentencing Review recommended legislating to ensure that short custodial sentences were used only in exceptional circumstances. So with your recommendation of the 40% reduction, how can the government ensure that those recommendations work together to solve the prison and court capacity crisis?
I don't see why they don't work together. Exceptional is a very difficult word. We had to construe what it meant in connection with IPPs, which are a terrible stain on our criminal justice system. It won't mean that people don't go to prison for short terms or for offences that you might not otherwise think. If you don't send anybody to prison for shoplifting, but you do send people to prison for shoplifting 27 times before lunchtime on Tuesday, while on bail and on a suspended sentence for shoplifting. And that's critical for our retail society, who are losing millions. So I still think it's the fact of going to prison rather than whether it's 8 months or 9 months or 14 months. It needs to be done.
Thank you.
Sashi, you wanted to come in on this?
Thank you. Sir Brian, in relation to your recommendation 27, the increase of the maximum discount to 40%, can I ask, did you speak to any groups representing victims of crime before you came to that conclusion?
I spoke to several victims' commissioners. I think there's a nuanced area here, because if a victim understands that somebody has pleaded guilty, in other words, they've admitted it early, promptly, to save them the stress of preparing for trial, of getting themselves into an emotional state to give evidence in court, I think that's quite important. But I certainly did speak to Baroness Newlove and to Claire Waxman, who is now going to be the next Victims Commissioner, to discuss their perspectives.
I ask this because constituents of mine are concerned already that a 1/3 discount is too generous and leads to unduly lenient sentences to criminals, particularly when they're caught red-handed. And why should someone have a 1/3 or an even 40% discount if they've been caught red-handed and there is, in fact, no realistic prospect of them being acquitted? And doesn't this lead to a fall in trust and confidence that victims have in the criminal justice system?
It's a fair point, and you're replaying an argument which I had when I was chair of the Sentencing Council about discounts for guilty plea, which I wanted to deal with slightly differently, but the committee took a different view. So what I say is twofold. First, sentences have dramatically increased over the time that I have been in practice. The amount of time people serve of the sentence has dramatically increased. So a 6-year sentence when I started the bar, 2 years you had to serve. You were eligible for parole after 2 years when you were on licence for 2 years, but then the last 2 years was remission for good conduct. Now, if it's an offence of violence, you have to do 4 years, 2/3, and you're on licence for the remaining 2 years. Sentences have dramatically increased. And the system has to operate, because if there is no discount or appropriate discount for people pleading guilty in very good time, the system will collapse. And if you look at the plea bargaining that takes place in the United States, for example, the differences are even more dramatic. So I recognise the concern expressed. I would welcome the opportunity to discuss with your constituents what the priority is here. and what they need from their criminal justice system by way of speedy outcome and accountability for the harm that has been caused. And I think that's a difficult question. Thinking about the discount on its own, I understand entirely.
The harm caused was their daughter was killed by a dangerous driver, and a 15-year sentence was reduced to 10 years for a max, 1/3 discount. And then, of course, that person will be released from prison even earlier for good behaviour. So what started off as a 15-year sentence ends up with the criminal being released perhaps after 5 or 6 years. Under the government's early release scheme, it may be even less. And that seems an unduly lenient sentence for someone that's taken a life.
Causing death is an incredibly complicated and difficult subject, and I empathise 110% with your constituent. I really do understand it. And you only need to look at the way in which we've adjusted sentences for causing death by dangerous driving. It started out, I'm sorry, I'm going back into history, 5 years, then 10 years, then 14 years, now life. And so society has increased dramatically the penalty for causing death. And there's a balance. I'm not in any sense diminishing the hurt that your constituent might well feel. And I've said it when I've sentenced defendants that the damage they've caused, the destruction of life to the family of the person, and the way they've destroyed their own lives and damaged the lives of people who love them. So I'm not diminishing that, but the system has to operate, and at the moment it just isn't. So I take your point about that particular example.
Thank you.
I really do, and I express my enormous sympathy to your constituent who lost a loved one. Sorry.
So Brian, time is against us. We're going to finish in about 5 minutes' time. We have the excuse of your Part 2 report to invite you back soon, I hope. I'm going to turn to Tessamant just to ask one last section. If I have time, I will come in briefly at the end.
So I've got loads of questions I wanted to ask you, but what I'm going to do is ask the chair to submit them to you in writing so that you have the luxury of
if you put something in writing, I will.
Thank you.
Deal with it. The people behind me will groan, but I will make sure it's dealt with.
Well, that's cool. I have got some I'd like to ask you now, just nonetheless, bearing in mind the time. So they will be fairly quick. I'm talking about your recommendation that we should establish a Crown Court bench division. I wanted to ask particularly how that division would affect the regime for the trial of youth offenders, and in what circumstances, if any, a youth defendant would retain the right to a jury trial under the new proposals.
Well, youths only get a jury trial, only go to the Crown Court if it's a grave and serious crime. So it's likely to be indictable only. And indictable only would not come within a bench division. But youths are tried for rape and other serious sexual offences in the youth court. And if they're tried in the youth court, then that's usually by a district judge sitting on his or her own. So if it's something less than if they're taken up to the Crown Court because there's an adult with them, then if it's within the parameters of a bench division, then they'll get a bench division. But that's what they would have got in the youth court anyway.
Thank you. My next question is one about the magistracy and the use of including magistrates in the Crown Court bench division. I wonder whether one might suggest that the magistracy doesn't always reflect the age and socio-economic diversity that one would seek, and whether it's realistic to expect a huge improvement in the diversity of the magistracy when the role is still unpaid and it's really only accessible to those who can afford to volunteer, which is moderately few.
I think this is a real problem. I recognise it as a problem. I know that the Ministry of Justice are conscious, and I've identified the need to recruit more widely if possible. I've encouraged some examination of the allowances paid to magistrates, or I will encourage it if I haven't encouraged it. It'll be in the next part. But I take your point that getting people to be prepared to take time out of their other lives to sit is a challenge. But there are those who are prepared to give up their time for community service, and I would encourage them to continue to do so. But I understand the problem.
Thank you. Can I just ask you one very specific question, and that is where the indications are that a defendant knows the sentence they're likely to get on a guilty plea at the first Crown Court hearing. So the judge gives that indication. Would he or she reserve that judgment to themselves, or would the indication be binding on the judge that does the sentencing?
Well, the only time you give an indication is if you're giving an indication for that moment.
Yes.
So in other words, it's that moment. So if, let's assume you ask for a Goodyear indication.
Yes.
The defendant asks and Goodyear permits the judge to provide an indication. The judge would then be bound by the indication he'd given, he or she had given. I'm not sure that I visualise the circumstance in which the case would then go off, because if the defendant doesn't take up the indication, there is no there is no undertaking for the future.
We have to draw matters to a close. The reason that we're doing this, Brian, is because we have the statement on wrongful releases from custody starting in a few moments. So I do hope we will have the pleasure of your attendance again. Could I just end by saying one thing, which you may know already, that a week ago we had the second reading of the Public Accountability Bill, known as the Hillsborough Bill, to us in the second reading of that bill. And there were 17 references to your report on culture, practice and ethics of the press by 12 MPs. So I'm sure
I'm pleased that it's still being thought about.
It's being, and as is Leveson 2, as is the model, as is the cost-shifting model that you recommended, as is the appropriate type of regulator.
Mr. Slaughter, you give me great pleasure.
Thank you very much.
Could we write to Sir Brian about that?
But I'm sure that we could. It's probably beyond our remit and the culture, media and sport. But I'm sure we could do that in an individual capacity, in which we could put our names to.
Very good.
But thank you very much for your...
You're very welcome.
Thank you. Thank you.